What's up, everybody? Welcome in. Today, we get our first look at the new defense attorney, and we get another look at the new prosecutor, but this time cross examining a witness, which he is a criminal defense attorney at the time and former prosecutor now as a special prosecutor. So, this should be his specialty. It should be where his strengths come out. And we're going to get to watch a bit of that today as they have a Dobert hearing to determine whether or not the defense's dog bite expert is actually qualified to testify about the things she testified in the first trial and maybe even more. So we're going to dig into this hearing. We're going to watch some clips, break down what we think was actually argued appropriately, how each of the attorneys did, and of course, answer all your questions. So let's get to it. So to set the stage a little bit before we jump right into the hearing, I think it's important to understand what the point of this hearing is. We are not here to determine today whether or not we agree with Dr. Russell's testimony, whether or not she has proven to us that this was a dog bite. That's not the question before the court. Part of a Dobert hearing, though, is what will your potential testimony be? And the state gets to cross-examine and see, is that actually something that fits into Dobert? Is that appropriate? Is this expert even qualified to testify about these things? Okay. So that's going to be an important factor as we listen to certain clips of the video and try to understand whether or not Judge Cannoni is going to allow Dr. Russell to even testify at this trial and what she is going to people are saying I forgot to say what's up. I didn't say what's up, everybody. All right, that's my bad. What's up, everybody? What's up, everybody? We're here. We're here, ready to rock. It's Friday. It's been a long week, but I'm really excited. Friday nights are so fun. Maverick plays flag football. Whitney coaches a cheerleading team for the high school basketball team here, so I'm excited. We get a lot of sports on Friday nights with the fam. So in this hearing, the really important things to focus in on are the expert, the expertise, the education, the experience, and whether or not she can even give us an opinion on these facts that are relevant to the case. Not whether or not we agree with that opinion, not whether or not the state is going to have an expert that says something that's the opposite. None of that. We're not really worried about any of that. So to set the stage, I wanted to just read some snippets about Dobert so you guys can understand what it is the lawyers are arguing about here and what the judge is deciding on. The 5 non-exclusive factors established in Dobert are whether the scientific theory or process has been generally accepted in the relevant scientific community. So generally, do doctors like her and people that understand these processes agree with what she's doing and how she's coming to her conclusion? 2, has there been or can there be subjected to testing? So is it testable? Number 3, has it been subjected to peer review and publication? So when you talk or when they're going to be talking about articles and was it published and was it peer reviewed, we're going to get into that. That's why, because it's one of the elements of Dobert. Number 4, has an unacceptably high known or potential rate of error. And number 5, I think I may have said 5 before, and this is number 5, is governed by recognized standards. In performing the Dobert analysis, judges may look to their own common sense as well as, and this is important, the depth and quality of the proffered expert, that would be Dr. Russell here, their education, their training, their experience, and their appearance in other courts to determine their reliability. So that's why you'll hear both sides ask questions like, have you ever been qualified as an expert in this before, in that court, to testify about this or to testify about that? Because that is one of the considerations a judge has to make when determining whether or not an expert can testify to whatever it is they want to testify about. A party offering an expert based on personal observations and clinical experience, such as those of a medical expert concerning diagnosis and causation, which is kind of what we have here, must show that the testimony is based on reliable principles or methodologies. However, if the proponent can show that the method of personal observation is either generally accepted by the relevant scientific community or otherwise reliable to support a scientific conclusion relevant to the case, such expert testimony is admissible. And I wanted to read that last part because as we get through Dr. Russell's training and experience, I think it's really important, and I probably would have named her something different in my expert disclosures. I don't even know what the defense actually named her as, but she's been coined the dog bite expert. The defense, I believe, has called her the dog bite expert. The prosecution has called her the dog bite expert. And so much of what she's doing is focused in on the dog bite. In my opinion, I would have just named her a causation expert. She is going to testify to the causation of the injuries on John O'Keefe's arm, what he presented to the emergency room with. ER doctors, pathologists commonly look at injuries and determine how they got there, if they're important. Sometimes causation can be really important as to how you're going to treat it or what the cause of death may be or who did this if it's a criminal case. All of that, to me, I don't know how you argue with her experience and her training, which we're going to get into. Now, if you want to coin her as a dog expert or a dog bite expert, I think it gets a little more difficult, but still, when we start to understand how the defense attorney built the expertise and education of this witness up, we start to understand why the defense gets there, right? So this was the first time, I think it's Alessi. I'll figure out the names eventually, right? Especially for the new lawyers. There's so many lawyers involved, which was evidenced at the end when they try to actually schedule this hearing coming up, because this was continued. We don't have an answer on this one yet. But from my perspective, this is what a Dobert hearing is supposed to be like. Sorry it was boring, right, at times, because that's what's going to happen. Sorry it was long at times, because that's what's going to happen. But you have to hit those factors: education, expertise, peer review, articles, publications, generally accepted, error rates. You have to get into all of that. And when your witness has as much education experience as Dr. Russel, it takes some time. And he methodically went through. Now, I will say I did listen to it on 2x speed. So I don't know if some people told me he was a little slow getting through it, but from my perspective, it sounded fine to me, right? Because I listened to it a little sped up. And from my perspective, he did a very good job of building that expertise. But before we even got there, there was a little bit of an argument as to whether or not the prosecution should have even been able to object to her being able to testify about this stuff because it came in the first trial. And what I'll say is, while it is frustrating, it is annoying. If something comes up to disqualify an expert, or she's able to testify in the first trial, think about if it was reversed and the prosecutor put forth an expert that was just completely unqualified. I know that may be hard for you to imagine, but let's say that happened and the defense is like, now that we've had the benefit of actually hearing how this expert testified in trial, there's no way this is an expert opinion. There's no way this person is qualified as an expert to testify about it. We object. They should not be able to testify in the second trial because it's an unfair trial to our client. I think most of us would be saying, yes, bravo, object to it, keep that person out. Let's make sure the second trial is done correctly, because the first trial is over, it's done. So while I understand the defense's arguments here, and we're going to listen to a little clip of it, generally speaking, I think it's okay for the judge, in the interest of justice, to hear further argument from the state. It's a new prosecutor, and see, should this person be allowed to testify? I do think that the fact that she was allowed to testify in the first trial should give you an indication that there's going to be basically a rebuttable presumption that she's going to be able to testify unless the state really shows the judge something different. So let's take a listen to just a little bit of the argument back and forth before the questioning even started.
Your Honor, I believe you have the discretion to make the decision that a Lanigan hearing is appropriate. I didn't have the benefit, but Your Honor certainly had the benefit of a voir dire prior to trial. Your Honor had the benefit of watching the trial testimony. Your Honor had the benefit of appreciating that it wasn't Rule 14 that was complied with prior to that hearing. In fact, a report was provided nearly 2 days ago on December 10th. And that—
Sorry, I do want to mention part of the issue during the trial was there a discovery violation? Was she a late disclosed expert? That's why her testimony may have been limited. All of that gets solved with a new trial, right? We get to do more discovery. We get to do this hearing. And, a lot of that gets solved. So that's why, frankly, she might be able to testify even more, not less, than what she testified to at the first trial.
That report, if the court has an opportunity to see it, is in conflict in many ways with the testimony of the voir dire, and it's in conflict with the testimony at trial. One thing that is constant from the voir dire through the report that we received 2 days ago is that there is an absence of methodology. There is no basis in methodology to support the opinions that have been provided by this witness. And that fundamentally supports the decision that the defense should meet the burden, be compelled to provide a witness so that they can see if they can satisfy the Lanigan Dobert statement.
So one of the arguments I take issue with there, I get what he's talking about. And, we can generally, I'm fine that they're having the hearing, but I believe that his argument that her opinion is a little bit different, right? Or maybe completely different. She has a completely different opinion. Let's just say that. And that's a big part of his cross that we're going to watch. Guess what? That's not a reason to strike her as an expert. That's fodder for cross. I hear people talking about the audio. As with every video that I put on here, I have boosted the audio as much as I possibly can. It is much louder when they're standing at the lectern and the witness is sitting on the stand. We will be able to hear that back and forth much better than what you just heard. The volume is the best I'm going to do, or the best I can do. So we'll try to move on from that.
Your Honor, he delved into the substance. I don't plan on belaboring it, but if I could just be heard. Sure. Thank you. Appreciate it. The methodology, and if we're going to go to the testimony, you will, of course, everyone will hear it firsthand, was established the first time. It's a pattern recognition. It's well established in the law. And that was what Dr. Russell testified first trial. That's in her report. And as we're to proceed, that's what will happen. That's first. Your Honor, it was a rule. The trigger for the last time was a Rule 14. But Your Honor, in the June 20th transcript, on pages 59 and 62, said, on 59, Your Honor said, you, the Commonwealth, raised Dobert-type concerns. And on page 62, Your Honor said, I have to exercise my role as gatekeeper. So it was clear that it was Dobert. The methodology was established. So I just wanted to respond in that manner for clarity of the record.
Okay.
I think that was an absolutely amazing point, right? Yes, the discovery issue is really what brought it up, but he took one phrase. The judge said that it's Dobert-like issues. So the judge was thinking and considering Dobert and still let her testify. Therefore, that should be applied today. I think that's a great argument. It didn't end up carrying the day, but I think it's a good reminder that if the judge is going to change her mind, she better give us a good reason why. And additionally, he asked, can you give us a reason as to why we're redoing this? And she's about to put her reason on the record. We might not like it, but it is a reason.
Additionally, after I made the finding that I made, I heard trial testimony. So based on everything, in my discretion, we're having a hearing.
Understood,
Okay.
Your Honor.
There are your findings.
Thank you.
Okay.
Not great findings, but I guess if you want to call them that, okay. Nicole, 50 memberships for everybody here watching. Thank you so much, Nicole. Christmas season. Merry Christmas, everybody. A lot of new members. Make sure you also hit the like button if you haven't already. All right. So then we get into Dr. Russell's testimony and they go through her vast experience, which I'm just going to kind of summarize so we don't have to rewatch the entire hearing together. But she was a cop, and I'm going to miss stuff. Okay. And you guys can throw it in the chat, but she was generally a cop, ER physician, ME, teacher, professor, writer, author, editor of articles, tons of experience in a ton of different areas, EMT, I believe, as well. This is the type of experience that any jury, when they hear it, is going to think this expert knows what she is talking about. And also why I don't even know how you argue with a straight face if I'm making her an ER doc, causation, trauma expert, how you even argue with it. Now, dog bite is such a specialty that, you can make it sound difficult. Like, how can anybody really become an expert in dog bite if this witness's education experience is not enough, right? She did 500 plus dog bite cases. She supervised even more than that. She said, I can't remember what number she said for the motor vehicle accidents. I'll look here. 400 to 500 dog bites, hundreds, if not thousands of motor vehicle accidents. I would be shocked if her time as a cop, EMT, and ER doctor, if she didn't have tens of thousands of motor vehicle accident cases come in while she was working in California at an ER. So tons of experience with that. And again, that's why I would kind of couch it. And these lawyers are smarter than I am. I've been doing it longer than I am. So I'm not throwing any shade at any lawyers. I'm just saying, as I'm watching and listening to this, we have a situation where somebody was brought to an ER because of either a dog bite or a car accident, right? That's kind of the question, the causation that we're looking for. So who's a better expert than somebody who has treated hundreds and hundreds and hundreds of dog bites and thousands of motor vehicle accidents? Who can compare and contrast whether this is more likely a car accident or a dog bite, right? This, with her education experience, to me, she seems like an absolutely perfect expert. And for somebody who has hired a lot of experts, who has laid the foundation and talked about education experience for a lot of experts, and somebody asked me, let me see this question here. Have you ever had a judge redo a hearing like this? So yes, what I was almost going to say is I've never had an expert get struck and not able to testify to what I wanted him to testify, but that would have been wrong because I have had a case where a judge struck part of an expert testimony And we did have to redo the hearing, and the judge ended up allowing, let's say I wanted the expert to be able to testify to 100% of things. And the judge was like, no, that he can only testify to 50%. Well, we redid the hearing and the judge ended up allowing about 75%, right? Not the full 100%, but we did get more. These hearings are redone from time to time. It wasn't after a trial, but I did ask for a rehearing and reconsideration from the judge. I've also, even a couple times in federal court, had expert witnesses that the federal government has tried to produce against our clients. And I've done a Dobert hearing and done multiple Dobert hearings, but specifically, there have been certain Dobert hearings that have gone much better than others where you go make certain arguments where the articles weren't peer reviewed. This person just kind of made up this methodology on their own. Nobody else has generally accepted it. And that witness has been struck. That's happened before in our cases, in real cases. And I will just tell you, it looks nothing like Dr. Russel. Dr. Russel, there have been certain cases where there's like these niche categories where they bring in a witness who's watched a bunch of YouTube videos and read a bunch of books from other people and written one article that he did while he was in school and he called it peer reviewed and he got struck altogether. That's very different than somebody who has done the exact jobs, right? The exact jobs that are necessary and that happen every single day for every single car accident and dog bite, EMT, ER doc, cop, right? And she's done all three, which is kind of wild to me that she has that kind of expertise and experience. And it's also wild to me that the Commonwealth is objecting to her with a straight face, knowing they threw so many cops up there just to say, well, they're a cop. So of course they're an expert based on their experience, based on a weekend course that they took. They're an expert. To me, it's like, I don't see how you argue that the same way. And if Judge Cannoni was to strike this witness, which I would be absolutely shocked if she struck this witness, she'll probably limit her testimony in some form or fashion. But to strike this witness and not to strike tons of the Commonwealth's cop experts would be a miscarriage of justice to me, would be wild to me. All right, let's actually get into her testimony a little bit more. Sorry about that. I put in here just with one or two of the jobs and experience that she had, she could be qualified as an expert to talk about traumatic injuries. She talked about guard dog stuff, canine stuff, partial versus full bite wounds. We'll listen to just a little bit of her experience just so we can kind of get an idea of the breadth of it.
At LACU bite wounds, did you observe and treat in the emergency department at LACUSC?
So the main emergency department?
Yes.
Well, over the course of all those years, at least 500.
How do you come up with the number 500?
Well, it was an estimate based on seeing, based on the number of years I worked, plus the number of weeks in a year, plus the number of dog bites that I saw per week. And that's how I came up with that number. And I underestimated.
Describe what you did, just briefly, with regard to the wounds. What type of practice of medicine, what did you do specifically with the wounds?
So when a patient came in with a wound.
And I'm talking dog bite wounds.
Okay, well, first I had to figure out if it was a dog bite. Because some patients couldn't tell us what kind of animal bit them. Most of the time they could, but some couldn't. Some were young, some, there were various reasons. There was sometimes language barriers. So I had to figure out what a type of animal inflicted the wound. And there was a very important clinical reason for that.
We're going to get to that. Okay. So I think you testified earlier about specifically what you did with the wound. What did you do specifically with the dog, these 500, approximately more than 500 dog inflicted wounds? What did you do specifically, so to speak, with your hands?
Okay. Well, I was clearly interested in wounds, and particularly bite wounds. I was very interested.
And she said multiple times that this is like a personal interest of hers, so she takes more of an interest than your average doctor would.
Interested in this, so it got my attention all the time. And so what I first do, I had to do a differential diagnosis.
And just to the last comment that she's not a hired gun, she came forward. Listen, you can call people on hired gun, and guess what? They get hired on a bunch of cases. Does that make them a liar? No. But you know what it does make them? Somebody that on cross-examination, I can say, you've been hired on thousands of cases, right? You've made millions of dollars being an expert testifying for them or testifying for them. And then the jury determines, does that hurt their credibility? Well, guess what? You can do the same thing to her. Guess what? You are, there's a situation where we're sitting here and you came forward, right? So you're not a hired gun. Yeah, but the other side can say, you wanted to be an expert on this case, right? You wanted to come and talk about this. You reached out to them, didn't you? Because you want to make a name for yourself in this world or whatever it may be. And they can try to use that to discredit her as well. And a lawyer probably will. So it just is what it is. But that's all cross-examination. That's not a determinant as to whether or not she's an expert qualified to make this testimony at trial.
But physically, if I determine it was a dog bite wound, then I'd render the appropriate treatment. Sometimes it was perforation of the skin and lacerations, and those lacerations sometimes needed debridement, which is cutting away from the edges and the dead tissue, any devitalized tissue, and some were large enough that they actually needed suturing. Many of them needed antibiotics prescribed.
In terms of the facility, I think you've testified that it was a level 1 trauma center.
Yes.
Did the fact that it was a level 1 trauma center have any effect on the number of dog bite wounds you would see?
I don't know the exact effect, but we did get referrals in.
And does the fact that
Like they would get situations or injuries that other hospitals couldn't handle, right? Or somebody shows up to an urgent care and they're like, no, you got to go to the level 1 trauma center, or, whatever it may be. That's all that means. They didn't really explain it a ton because probably most people in the courtroom understand what that means, but that's just a heightened level of experience that she has.
that it was a level trauma 1 center mean your estimate was conservative or liberal?
Oh, my estimate was conservative.
Meaning conservative, you say 500, but describe what you mean by conservative.
Conservative
Up or
means,
does it go down?
oh, I probably saw a lot more than 500.
Does that estimate include the number of dog inflicted wounds that you supervised?
No.
So in addition to the 500 plus, you also supervised. Describe what the nature of the supervision was with respect to dog inflicted wounds.
Well, as an attending physician at a university medical center, of course, I supervised interns, other residents, medical students, PAs, and nurse practitioners. And so frequently had, 3 to 5 people working with me that I had to supervise. So I would see I saw any case that they saw. Any patient that they saw, I would supervise. And when there were wounds, I would look at the wounds personally myself.
How many trainees did you typically supervise per shift?
Typically 3 to 5.
So in addition to the 500 plus, you were supervising 3 to 5 trainees per shift who also were treating dog inflicted wounds?
Yes.
And can you give an approximate number of dog inflicted wounds, just approximate, that those trainees would be experiencing in their role?
It's so hard to give an estimate. But with all those trainees and all those weeks and years, I would say at least another 500.
Have you ever participated?
So again, tons of experience, dog bites and otherwise. EDB said yesterday the LADA told AJ about her and he reached out to her. Yeah, but I'm pretty sure I remember from the first trial that she initially reached out to somebody. I could be wrong about that, but I'm pretty sure that came out in the first trial. Regardless, they're going to find something to ask questions to try to discredit her. Every lawyer does it in every case. They get into her knowledge specifically about dogs, mouths, teeth, how she wrote articles, edited articles on it. Was it perfect? Is she a dental expert? No. Is she specifically a canine, veterinarian expert? No. But as far as an ER doctor dealing with trauma, dealing with dog bites and car accidents, guess what? Vets are going to be terrible at trying to compare car accidents to dog bites. So scientists or dentists that just deal with teeth, they're not going to be able to compare car accidents with dog bites. It's just not going to happen. So from my perspective, she sits in the literal perfect chair to be a trauma expert comparing car accidents and dog bites. That's really what I would have couched it as. Again, it's not very different than what they couched it as, but with all of her training experience, to me, I don't know who do you want? What experience do you want except for somebody that just takes years of courses on, measuring dog teeth and how different they are and how far apart they are and things like that. Then I think we get to what her actual opinion is. I want to hear that.
Laboratory.
Yes.
Did you look at the UC Davis
So
veterinary?
he's just finishing his line of questioning as to everything she reviewed, everything she looked at, and helping her make her decision or her opinion, form her opinion.
Genetic laboratory case report.
Yes.
Did you look at a report from a Paul Mikowski, a licensed private investigator, on interviews regarding Brian Albert's German Shepherd dog?
Yes.
Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes.
What is that opinion?
Those wounds were inflicted by a dog attack.
Do you hold that opinion to a reasonable degree of medical certainty?
Yes.
All right. Now, if you remember in the first trial, there was a lot of struggle with to a reasonable degree of medical certainty. Does she understand what that means? She was much softer on it. She was not as clear and convincing and convinced herself about that testimony. Okay. And that's going to be a big part of Gwyneth Garnett. It's a great point. Vets don't see dog bites on humans. You're right. That's a great point. That's a great point. This is my point. This is who I would get. If I was a lawyer and I'm looking for an expert on this situation, this is who I would get. Not a vet, because that would be very dumb. But this is an important point and an important factor. And this is going to be something that Hank Brennan's going to hammer on his cross. And if she is allowed to testify at trial, he'll hammer it there too. But guess what? That's not the question before the court today. The court is not determining whether or not there are differences in her testimony or impeachment material. Is she qualified to make this decision? I will tell you, we've had cases. I'll just tell you, we've had cases where a doctor has had an opinion, gotten more information, and that opinion has changed, has shifted a bit, has completely flipped on both sides, my experts and the other side's experts, because with more information, that can change how a doctor thinks something is caused or what the treatment should be for a person. It can be incredibly important. Let's listen just a little bit more. It's like another minute.
How did you form that opinion?
Well, I utilized my many years of training experience with wounds in general and dog bites in specific, and went over the materials quite a few times. And with that, and plus did read up on some literature that I had read in the past and reread again. And that's how I came to the opinion.
Now to get a little bit more specific, did you?
So one of the things that's interesting about that as well is in the first trial, because it was kind of like thrown together, they didn't have enough time, there wasn't a continuance, things like that. I personally think, after listening to her testimony here, because I don't think she was that strong in the first trial. I think it was a good point, a good box to check for the defense. We heard more than the jury did because of all the stuff that happened outside their presence. I didn't think that it was that strong. And after listening to her testimony yesterday, I feel like she could be much, much better and stronger for the defense. And guess what? If they have any argument or problem with her testifying to any more or a wider scope than what she testified to the first trial, we redid everything here, Judge. We've given you all our expertise. We've given way more opinions in this Dobert hearing. So it's pretty much all fair game unless the judge limits it. But there's going to be more on that later. She also talks about how she, differential diagnosis, she ruled out self-inflicted for the wounds. She ruled out a fight with another person, which I thought was kind of interesting. And maybe I would have asked about that if I was a prosecutor. Did you look at his head? Did you think that was not from a fight with another person? And it was not from a motor vehicle accident. So she ruled those out. And he asks her, why don't you think it happened from a motor vehicle accident? And for me, as important to the, conspiracy theory and the cover up and all that, as important as the dog bite injury is to that, ruling out motor vehicle accident is more important to me, because that pokes a major reasonable doubt sized hole in the Commonwealth's case. So she is not a dog bite expert, I wouldn't say. She is an expert looking at these wounds and determining causation, what caused them. And she considered self-inflicted, fight, dog bite, and motor vehicle accident.
Right arm.
Because he was found outdoors.
And what other reasons? Was there anything about the nature of what was presented and what you reviewed with regard to his injuries that caused you to rule out motor vehicle accident?
I think I misunderstood the previous question.
So, yeah.
Yes. So,
Let me start over.
Yes.
Because I am going to take what you said. So let me ask it this way. What caused you to rule out a motor vehicle accident as a cause of the injuries to Mr. O'Keefe's right arm?
there were several reasons I ruled it out very quickly. One is that the wounds were not characteristic of anything that I could attribute to a motor vehicle, a certain part of the motor vehicle, the underneath part of the motor vehicle. They were just not characteristic of any particular part of the motor vehicle. Secondly, there were no bruises from the neck down on his body. There was a mark on the hand, which I think I have an explanation for that.
Please.
Which was not a motor vehicle, but I didn't see any bruises or fractures or other blunt injuries that were characteristic of a person being struck by a motor vehicle. And if I can add to that,
Please.
we at the coroner's office forensic pathology program was specifically trained on how to recognize not only if someone was struck by a vehicle, but to even recognize further about what types of vehicles would inflict, what types of wounds, and the locations that we should look for on the body for wounds for someone that's struck by a motor vehicle.
Have you ever taught in all your careers?
So then they go back into her training experience, how she taught stuff, classes on identifying injuries from motor vehicle accidents. They look at pictures of a injury that came from a dog named Chloe biting the hand of somebody. She talks again about entry and exit wounds, about the testability and the reliability about this stuff and the general acceptance in the scientific community. All very important boxes to check for the Dobert standards. She talks about how all of her opinions here are based on her training and experience to a reasonable degree of medical certainty. And that's why I said, my tweet about this new defense lawyer is, was it the most riveting direct in the world? No. But guess what? There's no jury there. Doesn't matter. I'm not trying to impress anybody. What we're trying to do is check the boxes we need to check as an attorney in a Dobert hearing. And I literally think he checked every single one about as good as you can possibly check them. He prepared this witness incredibly well. I think it went so much better in this hearing than anything we saw in the prior trial. So kudos to him. A job well done, in my opinion. But I was also very excited to see Hank Brennan cross-examine a witness. Some people have said, he sounds a little weaselly or villainy or whatever it may be. And, he's a little soft and whatever. I felt like his real personality and lawyering and criminal defense attorney came out in cross-examination, because that's such a big part of criminal defense attorneys' jobs and what they do. And he basically came out swinging. So we're going to listen to right how he starts with cross to make his point to the judge as to what he wants to get out with this witness and the issues he sees in her testimony.
Arms, legs, toes.
Yes.
In light of your extensive experience in the emergency room and looking at all of these broken bones, that doesn't make you an expert in orthopedics, does it?
Yes.
You see physical
I'm going to back up, sorry, because I need to go from the beginning here.
and had the pleasure of meeting before.
Good afternoon, Mr. Brennan.
I'm going to ask you a few questions if that's okay.
Yes.
Thank you. You shared with us that you have an extensive history of experience in the emergency room.
Yes.
And in the emergency room, you see all types of injuries, don't you?
Yes.
You see physical injuries, yes?
Yes.
Emotional injuries,
Yes.
people who overdose, perhaps they're drunk on drugs,
Yes.
alcohol.
Yes.
So you cover a wide array of different types of treatments.
Yes.
Now, you must have seen a number of broken bones when you were in the emergency room caring for different patients, correct?
Thousands.
Arms, legs, toes.
Yes.
In light of your extensive experience in the emergency room and looking at all of these broken bones, that doesn't make you an expert in orthopedics, does it?
So let's talk about that. First off, I've done a lot of trials with orthopedic experts, right? Neuro experts, surgeons, non-surgeons, whatever, maybe a lot of medical experts. Okay. And never have I ever gotten an expert disqualified because I said, you're testifying about this type of injury or accident, and you have had cases that deal with this other part of the body, but you're not an expert in that part of the body, right? He's asking her if she's an expert in orthopedic, which frankly, she should say no, she's not a board certified orthopedic surgeon, but she absolutely could be an expert to testify about broken bones and how bones break. And if somebody came in for a car accident and the defense attorney said he didn't break that bone in a car accident, that bone was broken, years before. And she could say, I looked at pictures when he came in the ER, it's a displaced fracture, whatever it may be, and give her test. She absolutely could be an expert for that. Would she be the best expert for that? Probably not. You'd probably want an orthopedic surgeon, but she could be an expert for that. And guess what else? Just because you're an orthopedic expert or doctor doesn't make you the right expert for all different kinds of injuries, like an orthopedic spine surgeon versus an orthopedic extremity surgeon. And guess what else? I've had cases where an orthopedic extremity surgeon, all they do is shoulders, knees, hips. That's what they're board certified in, comes and testifies to the neck surgery. They don't get disqualified. Frankly, to be honest, I didn't even try to disqualify them because I know the defense could just go get a neck surgeon if they want to. But instead, I'm like, great, come be the expert. Dr. Smith will say, when's the last time you did a neck surgery? Oh, you never have. When's the last time you did a radiofrequency ablation? Oh, you never have. When's the last time you did the post-op physical therapy or post-op meetings with clients after a neck surgery? Oh, never? That's great, right? So guess what? If he wants to ask her a lot of these questions when she testifies to try to say she doesn't have the proper knowledge, fine. But these questions do not disqualify her to be a medical expert. So basically he's saying because she didn't specialize all the way down to ortho, neuro, cardio, that she just can't be an expert, which is just not how it is. I don't think it's a bad line of questioning. I just don't think it's going to accomplish what he wants it to accomplish.
Emergency orthopedics, yes.
Have you ever been qualified as an expert in orthopedics?
And that's the other thing. She said emergency orthopedics, and I would agree with her. She would be an ER doc expert, a trauma expert probably. But he wants to pare it down to the very specific specialty, which he's right. That's the best expert to get, but that's not the only one. That's not what Dobert says.
Orthopedics?
No, I've never orthopedics, yes.
Sorry, we will listen to some of this without me interrupting so much, but he then is going to ask a lot of questions about, have you ever been qualified to be an expert in this? Have you ever been qualified to be an expert in that? That's why I wanted to read you the factors in the beginning. And one of those factors was, have you been recognized as an expert before? And that is a factor to consider. But guess what? Every expert in the history of our justice system had a first time they were qualified to be an expert. So just because you've never been qualified to be an expert before doesn't mean you can't be an expert now. But it is a tally in the Commonwealth's corner, right? She's never been an expert in this before, so we'll check that off for the Commonwealth. We checked off education, experience, peer-reviewed, acceptable in the scientific community for the defense so far.
Have you ever been qualified as an expert in orthopedics?
No, I've never.
Isn't orthopedics a specialty in medicine where there is specific training?
Yes.
And people who become orthopedics or orthopedic surgeons, they go through rigorous education specifically to be an orthopedic, right?
Well, orthopedics involves more than just setting fractures or diagnosing fractures. Orthopedics involves things like bone tumors, bone cancers, a lot of other parts of orthopedics, not just trauma. I am an expert in emergency orthopedics, I believe.
So you have decided that you are an expert in orthopedics?
Emergency orthopedics.
Emergency orthopedics, is that a specialty that you get a fellowship in, or somehow you are deemed an expert in any way?
It's not a specialty that has a fellowship that I'm aware of.
So you are proclaiming that you yourself think that you're an emergency room orthopedic?
I have.
And guess what else? Using like the kind of sarcastic, so you're the one that thinks you're an expert here. Maybe that would work on cross, right? In a trial. Maybe a jury would look at this expert and be like, she is so pompous. This lawyer's doing a really great job. I'm not getting that feel, but no, the lawyer is doing a good job. I mean, I'm not getting the feel that this doctor is very pompous, but you can say, oh, you're the one that thinks you're an expert. Oh, okay, but nobody else said you're an expert. That goes to her credibility in cross-examination. The kind of sarcasm is not going to prove that she's not qualified to testify to the relevant facts she wants to testify to in this case.
Have expertise in emergency orthopedics, yes.
Are you an expert in orthopedics?
The whole field of orthopedics, no.
And you don't have any special
Very few doctors should be an expert in the whole field of orthopedics.
degrees in orthopedics, do you?
No.
You would agree that somebody who's gone through the rigorous requirements of being an orthopedic and qualified, they'd have much more experience in that than you. True?
In general orthopedics, yes. I have a lot of experience in orthopedic trauma related to emergencies.
Have you ever been in any court where you've ever been qualified as an expert in orthopedics?
It was never an issue.
But I'm asking you, have you ever been in any court, state, federal, this country, any other country, where you've been qualified as an expert in orthopedics?
No.
Has anybody other than yourself ordained you as an expert in orthopedics?
I haven't ordained myself as an expert in orthopedics. I have a lot of knowledge and expertise in emergency orthopedics.
Has any authority
That's a disrespectful question, in my opinion, right? Has anybody else ordained you an expert? It's like, sir, if I was her, because she's a little nicer than I am, I would have been like, sir, nobody's ordained me anything. I've worked, I've gone to school, I've gotten a ton of experience in education for years and years and years. How long have you been a lawyer, right? If I really want to be disrespectful, I'm like, how long have you been a lawyer? Well, I've been doing this for a lot longer. Do you think you're an expert lawyer? Well, I'm an expert doctor. You know, it's like some condescending lawyers ask for responses like that from witnesses. It's not becoming for a witness either. So I wouldn't recommend her doing that. But I can understand how she would be frustrated with him using words like, so you ordained yourself as an expert, but nobody else has.
ever recognized you and qualified you as an expert in orthopedics?
No,
Just you again.
I haven't declared myself an expert in orthopedics. I have expertise.
You've seen a lot of car accidents you shared with us
Yes,
as a police officer
yes,
in the emergency room.
yes,
Perhaps when you were at the ME's office, you saw the consequences of car accidents.
I did, yes.
Are you an expert in accident reconstruction?
Reconstruction, no.
Okay. That to me was one of the worst questions of the entire time. He sets her up, right? You handled lots of car accidents as an ER doc, as an ME, maybe even as a cop or EMT, whatever he said, right? And she says, yes. And he says, so are you an accident reconstructionist expert? And she says, no, which is the right answer, obviously. But what I would have loved to hear her say is, I'm not an expert in the accident reconstructionist, but I am an expert in the injuries that car accidents cause. Because he's very clearly trying to say, fine, you have all this education experience, but you're not an expert at what we need you to testify to here at trial. And I think that is completely off base because he just built up her expertise in what she actually wants to testify to. And that's comparing car accident injuries and dog bite injuries at this trial.
And when you see the different people that come in with overdoses, whether it's alcohol or drugs, you treat them, don't you?
Yes,
But you're not an expert toxicologist.
I'm not a toxicologist, no.
Obviously not.
But toxicology is a part of emergency medicine. So we have training in orthopedic in toxicology, but no, I am not an expert in toxicology.
I'm not suggesting you're unfamiliar with it or you haven't had experience or some training. I'm asking you if you think you're an expert.
In toxicology?
Yes.
No.
And you've shared with us that you agree you don't have any expertise.
But she can testify to what alcohol does to a system. Almost every doctor has been able to testify that like alcohol is a depressant, right? You don't have to be a toxicologist to say any medical thing about medicine, especially if somebody comes into the ER and that's what you do. He's changing the bar a little bit, right? He's elevating what is necessary to be an expert. And to me, that's kind of like Trooper Paul is the elephant in the room, right? I'm just going to say it. The guy's not an expert. He's got nothing that would qualify him as an expert. The bar is not super high to be an expert. Maybe some people argue it should be higher. Based on the case law and the statutes and most of the jurisdictions I'm familiar with, it's a high bar, but it's not a crazy high bar. She clears the expert bar by leaps and bounds. And again, if any of you guys have watched any trials on YouTube or any lawyers out there that have had cases and hired experts, that's just a known fact to me. Shelby asked the question, if you were the prosecutor, what would you do after all the testimony given on direct? There's some things he asks that I would have gotten into as well, which I will highlight when we get there, that I do think he does a good job at. What I would have done, I wouldn't use the word nibble, but I would bite around the edges and try to really limit her testimony to, I think this was a dog bite, not a motor vehicle accident. Fine. But like the measurements and how the teeth work and how they're all set up in a canine's mouth and that type of stuff, I would try to limit that because I don't know that she has that expertise just by reading some articles. She hasn't studied dogs' mouths or their teeth, so I would try to maybe limit that to make it seem like she doesn't have quite the vast knowledge and experience about dog bites specifically, or how the jaws are shaped. He does get into some of that, which I thought was good. He brings in some of his own research, which we're going to hear about. But I would have tried to, frankly, if I could have just said, Judge, as long as she's only limited to what she testified to in the first trial, I'm fine with it. If we could have just had an agreement with the defense on that, I probably would have taken that because I don't think she was overly effective in the first trial.
That's correct.
In fact, you know very little about DNA, don't you?
I would say that's pretty reasonable. Yes.
That's what you said.
Yes.
You mentioned that you are generalizing or approximating the number of dog bite cases you've attended to in the emergency room relative to civilian dogs or domestic dogs. Is that right?
Yes.
And you suggested that you probably treated about one dog a week over a period of 27 years. Yes?
Yes.
Which is 1,000 weeks in your estimation.
Yes.
You worked for some of the most busiest ERs. Was there a lot of patients every day that you treated?
Yes.
On average, how many patients would you treat in the ER over those?
I'm going to jump ahead just a couple minutes, but basically what he's getting at here is less than 1% of your cases were dog bites. So barely any of the stuff that you did was dog bites. Okay, fair. I think that's a good question. I think that's good. It's like a very small percentage of what she did is dog bites. Here's the problem. This isn't a doctor that's been a doctor for 2 years. Therefore, she's only had 2 dog bites. When you've been doing it for this long, even just 1% or less than 1% is 500 dog bites. Like, so what do you need? So every cop that comes up, the defense can ask a question and say, how many cases like this have you worked? 200, not enough, because apparently 500 is not enough. Or if you've been doing it for 1,000,000 years as a cop and it's like, I've done 1,000. Well, that's only 1%, not enough. That's why there's nothing in the case law that says you have to have worked on X amount of cases to be an expert. There's nothing that says that. You look at the totality of their education and experience and what they're testifying and the methodology and how they came to their conclusion. Is it reasonably acceptable? Is it testable? Peer-reviewed on it? Have other people looked at it and said, oh, that's junk science, let's throw it away? Or have they said, no, this makes sense? That's what you're looking at.
There were a few occasions when I had to use those skills in order to determine what kind of an animal it
Let's
was.
talk about those few occasions. Why don't you share with us a story where you met the patient?
All right, so here. So they start getting into, okay, so you've dealt with these dog bite stuff. And here I thought was a very good line of questioning by Brennan. Whenever you feel, and a lot of being a lawyer and asking questions on cross-examination, a lot of his feeling, it's like an art. And you're dancing here. You're battle dancing a little bit, right? When you feel an expert start to go vague, I've done some of this, I've done some of that, I recollect a little bit of this, using language like that, start to ask for specifics. You can step in it, but it doesn't really matter. It's in front of the judge. If they have specifics, that sucks for you. But a lot of times, if they go vague, they might not have specifics. And if they don't have specifics, now you start to get to the judge. Judge, they're just saying stuff. They can't remember a single case or a single time they actually put this into use. And that's what he starts to do here. And I think he does a pretty good job of it.
Let's talk about those few occasions. Why don't you share with us a story where you met the patient, if you can recall, where you had no idea what the injury may have been, no ability to communicate, and tell us about how you determined it wasn't on.
For anybody that couldn't hear that, he's like, tell me a case where the victim who comes in or the injured person, the patient, can't tell you what happened, and you've used your methodology here that you've testified here to today to determine that it was a dog bite. Because that's what we have here. John O'Keefe didn't come in and say, hey, got a dog bite here. And she's like, yep, that looks like a dog bite. No communication. You're just looking at the injuries. And just by looking at the injuries, you're able to determine that it's a dog bite.
Now, thinking about a specific case, I can think of cases where I determined it wasn't a dog bite, it was something else based on the pattern of the bite. And am I not answering your question?
I'm not looking for cases.
I would have loved it if she would have said, I've done it where they come in and I've determined it's a car accident and not a dog bite. Because I'm sure she's done that, right? Hundreds or thousands of car accidents come in and she's like, yep, this is a car accident. Looks nothing like a dog bite. I would never think it was a dog bite for a million reasons, because she probably did that a ton of times, right? I would have loved that answer.
You couldn't determine the dog bite. I want you to share some of this law experience as a dog bite. Share with us, if you will, one of the cases where there was no information that was a dog bite, for whatever reason, and then you, based on your pattern recognition skills, determined it was a dog bite. I want you to walk through an actual case that you can recall you had with this scenario you presented.
You know, I can't give you a specific case because, again, in the overall scheme of emergency medicine and the frequency that dog bites are to other cases, it's just not a case that I would remember, that kind of the specifics of the case.
See, I think that's a good point for Brennan. She couldn't remember a specific case where he comes in and she makes the determination using this methodology, which she says is reliable and peer-reviewed. To use it, you should be able to say, I've used it. Somebody's come in, they passed, or whatever the issue is, they were incapacitated, and I was like, this is a dog bite. You should be able to do that, right? If she's saying that's what she could do now, or maybe looked at somebody after the fact to make this determination. Now, even after saying that, of course, could be the first. You could be the first. Asia said, Peter, what are the chances that this backfired on the prosecution by the defense applying the prosecution own standard of the prosecution's experts? So in like our world, in a theoretical world, yeah, it's a big deal. It looks horrible for them, for some of their experts, but in reality, the judge isn't going to do that. The judge is going to take it on an individual expert by expert basis. And she's not going to say, oh, because I struck this expert, I'm going to strike your expert. It's just not how it goes. But like anybody with a brain watching this is like, they see a very big difference between the prosecution's accident reconstructionist and this expert in any medical diagnosis. I would trust her opinion. Basically any medical question I had that would, take me to the emergency room over some of the prosecution's experts from the prior case.
In supporting your past experience, share with us the size of the past experiences and presenting yourself as an expert in pattern recognition. And it's interesting that when I'm asking you details, it's what this general.
Objection, Your Honor. Argument.
Yeah, so,
I'm
counsel,
sorry. Yeah.
that's okay. In Massachusetts, typically, we don't give the reason for objections from the floor. Your objection sustained, no commentary, Mr. Brennan.
So she does shut down Brennan as he's kind of arguing with the witness because he's like, I find it very interesting that you can't give me a single reason, but I think it's a point well taken. I honestly do. Then they kind of get into the articles and what articles she wrote versus edited. Did she ever physically see with her own eyes the mechanism of a dog bite injury? And it's like, you don't have to do that, right? That's not something that's a prereq. But he asks those questions and then he's like, have you ever read this book? And she's like, no, I haven't. And he's like, oh, well, doesn't it say hourglass shape or whatever? I thought it was a good line of questioning. I don't know what that book is. He's going to have to explain to the judge why that book is more reliable than Dr. Russel. But is it a peer-reviewed book? I don't know. But she and the defense has produced peer-reviewed articles that she either wrote or edited, which again, checks the box. They don't have to be the most read article in the world. They don't have to be she doesn't have to write the book on dog bites to be an expert in dog bites, because then there'd only be one dog bite expert, right? Charles Earhart would be the only evidence expert in Florida. And that's just not how it works. But again, I do think, so she does say at some point, you should read these articles. He's like, I have. And you can tell he has. He's smart. He's prepared. He's read these articles. And he was asking very specific questions to try and trip her up or make her seem like she doesn't actually know what dog bite experts would know. And I didn't think this was a bad spot for the Commonwealth. I thought he did a pretty good job sparring with her on some of the specifics of dog bite stuff. And we're going to listen to a little bit of it now.
Article in pattern recognition.
Well, you said in your report that you reviewed scores of peer-reviewed articles on dog bites.
Dog bites, yes.
Okay, so those didn't really include pattern recognition as you've described your expertise today.
Some of them did, some of them didn't, but that might not have been the major focus of the article.
Which ones did? Can you reference us the ones that you've read and relied upon, in your opinion today, that have to do with pattern recognition analysis?
May I look at my...
So again, he's picking up on some vagaries in her discussion and her answers. He's like, point me to some specifics.
My report or my CV?
Sure, sure. Go ahead and take your time, Doc.
Thank you. Okay, there is, and they might not have used the term pattern recognition, but that's what they're talking about in these articles.
Okay.
There is a article by D. Munich it's actually listed in my report under literature.
Okay, I see it.
It's the third one. Yes.
And that deals with pattern recognition analysis?
It's part of the article. There was a lot more in the article than just pattern recognition. And again, they might not have used that specific term pattern, but it's what the subject was discussed in the middle of the article. Yes.
What was discussed in this article that you relied upon?
Oh, I relied on the descriptions of wounds. I relied on a lot of this article.
Well, share with us in detail. Could you tell us what you relied on in that article as part of your opinion?
There was a description. There was an area that described wounds and fatal wounds in dog bites, and how to approach them. You know, how to investigate them. There was an area that described what some of these wounds look like. And there was actually an area that I believe it was this article that said that if you have this plus this plus this, that it is pathognomonic for a dog bite. Now, I believe that was the article that said that. One of these articles did, but anyways, so yeah. So I think maybe you might want to look at them.
Oh, I did.
Okay.
That's why I'm asking you.
Okay.
That's why I'm confused about which one you're talking about.
And that's inappropriate, right? He's like making an argument with her, like, I don't think you're saying it appropriately, but that's eventually going to be up to the judge to make the decision. And he can make that argument in his motion, right? In his objection, his motion to strike her as a prosecutor, but not appropriate banter back and forth with her on the stand. Listen to a little bit more.
There was not a recipe book that said, okay, you know, this is the pattern of a dog bite. It might not get a lot of readers for that, but this was a forensic approach as to how to identify fatal dog attacks.
So from your resume, doctor, could you tell me which article you're talking about?
I'm talking about the third one down.
I thought she did a good job. She's like, there are elements of what I've learned and what I'm testifying to in multiple of these articles. None of these articles say this is exactly how you determine a dog bite. No, but they determine different injuries, different bite patterns, what the difference are between human mouth and dog mouth or animal mouth, whatever it may be. To me, I thought she answered the question fine. And again, if Brennan wants to say that's not good enough, those arguments are a joke, nobody believes, then argue it. Argue it. But she thinks they're good. If they're peer-reviewed and generally accepted in the scientific community, the judge doesn't really have a choice. She really just does not have a choice. Discworld said, what happens if Judge Cannoni disqualifies Dr. Russell? Could the defense argue it's an abuse of discretion in your opinion? They can argue, they can file a motion for reconsideration, trying to get her back. They could also, because she has struck this witness, say, well, Judge, we want leave to go find another dog bite expert. And they could go find another dog bite expert if they really want to, and go look for one that, you know, has more specific dog bite prereqs. I don't know how they're going to find one better than her, honestly, especially to compare with a motor vehicle accident and what the injuries are more consistent with personally, because I think she's about as experienced and has all the education you would ever need. But they could also do that. If the judge continues to deny it, it would be an appellate issue. All right, let's see what part is next here. She agrees she's not an expert on self-defense. She agreed she was not an expert on a lot of things. So at the very least, you know, the question before, what would I do if I was the prosecutor? I would make sure to delineate all the limitations in her testimony. Not a DNA expert, not a self-defense expert, not an orthopedic surgeon, not a toxicologist, et cetera, and make sure all that's delineated. And so you can look at that ruling and say, look, Judge, she can't testify to X, Y, and Z. I wrote down in my notes, I just take like random notes as I'm listening to this. It says, I almost laughed when he said, do you have a degree in biomechanics? And she says, no. He's doing a great job of crossing a qualified expert, but it makes you want to barf a little bit knowing the prosecutors just throw cops up there to get in to be an expert at whatever they want to be based on training experience. Because it's like, if having a biomechanics degree is what it takes to be a dog bite expert, then what does it take to be an accident reconstruction expert? Because all of them were let in. Literally, cops just like take a weekend class on stuff and they are now a certified expert in X, Y, and Z. It's wild. Okay, so we're going to listen to the last 10 or 15 minutes here of Cross, because I think this is where he does the best job. This is where his personality comes out. This is where we get a little taste that he is going to do a much better job cross-examining witnesses in trial too. That's just my opinion. I think Brennan is going to do a much better job cross-examining witnesses. He's going to be much more direct, much more authoritative than the prosecutors in the prior trial. And this is where I think, like, we'll see. We'll see if he can destroy her credibility enough in front of a jury. If he can just say, no, that doesn't make sense, or that doesn't line up, or she's biased, or whatever it may be. And I think he does a good job here. But it's important to remember, as Michelle said, challenging her medical opinion is not the same as saying she's not qualified to give it. If Hank wants to challenge it, he should bring in his own expert and testify on rebuttal, ridiculous hearing. Here's what I'll say, Michelle. Not just does he have to bring in his own expert to challenge it, he can challenge it in cross-examination during trial while the jury is sitting there and listening. It's fair game to cross her on it, but it shouldn't be a reason to disqualify her as an expert just because you don't agree with her opinion.
And to determine, well, what was the worst possibility? That's the way I approach it. What is the worst? Could it have been a rabid animal, an animal with rabies? Or was it an animal that doesn't carry rabies? And then based my treatment on that, sometimes you have to treat broadly, and sometimes you have to, treat people for conditions, even if you don't know 100% that they exist.
Are there times when you saw injuries that you just didn't know how they happened?
Yes.
Many times. Yes?
Yes.
That's a good question for a lot of the Commonwealth's witnesses too, right?
And many times you thought what you saw were bites, but you couldn't articulate the animal, right?
That happens sometimes.
Okay. Suffice to say, you have never, ever been qualified in a federal court to testify as a dog bite expert, have you?
No.
And
other than this trial a year,
I think that's a great question. I think that's a great point. I think that's a check in the box for the Commonwealth, that she's never been qualified before. That's not enough to disqualify her this time, but it is a good point to belabor, and he did that.
ago, have you ever been qualified to testify in any state court in the entire country as a dog bite expert?
No, the issue never came up.
That's not what I asked.
Okay, no,
No. You wrote a report in this case?
yes.
Now, there is a difference between being not ever being qualified and being disqualified or found to not be an expert. So I would guess that on redirect, which is going to happen in January, that the defense attorney is going to get up and say, okay, you've never been qualified as an expert before. Have you ever been produced as an expert and a judge said you are not qualified to be an expert in this area? And I think her answer is going to be no. And that's a very big difference, right? It's a big distinction to have been refused to be or struck as a witness versus never presented before. So now this judge is going to make the decision for the first time, actually the second time, because she's already been qualified in this case.
Did anybody help you write this report?
I wrote the report. I had some help with some minor edits and rearranging, some paragraphs or whatever, but putting things in the right category.
Okay.
But no, I wrote the report.
Who helped you with your report?
Mr. Alessi.
And now we start to get into the multiple versions of her report. Is it a big deal, right? This is going to be a question a lot of people ask. Let's listen to this back and forth, and then we'll get into if this is a big deal and how it can be used at trial.
So did you write a preliminary or draft report, send it for input, and then change it?
No, I didn't change it. I wrote the report, and I would have things in the wrong categories, for instance, like training experience or whatever.
Who said they were the wrong category?
Well, I think that was my conclusion, actually.
I see. And so how would you go through this editing process? How did that work on this report? Would you send it back and forth?
It got sent back and forth a couple times.
Okay. Now, this report you signed, right?
Did I sign it? Yes.
Nobody else signed it. You.
I wrote it.
Okay. And the reason why I asked if you had help, a lot of your statements and conclusions in this report are different than the testimony that.
So before we get into the differences in her statement, is that a big deal that, they went back and forth with a lawyer? Some lawyers hate it, don't ever want draft reports because in a lot of jurisdictions that's discoverable. All the different drafts are discoverable. So if she says something in one report and the lawyer's like, no, you got to change the facts or say this or whatever, it can be really bad. Depending on what the changes are, it can be really bad. If a lawyer rewrites an expert's report, that's very bad. If it's minor stuff where it's like you spelled the client's name wrong, or like she said, you put education here and experience here, you got to flip these, this course technically is education, whatever it may be. That's no big deal. Complete nothing burger if the substance did not change in the multiple drafts. And just like, did you talk to the lawyer before this? Did you prep? How long were you on the phone with the lawyer prepping? It's like lawyers prep witnesses, big deal. So I don't think it's a big deal, but sometimes they do present it in front of a juror, and it's really going to be up to the individual juror if they think, oh, she is a hired gun. This lawyer told her what to say, multiple versions of the report. That's really the only way it becomes a big deal if an individual juror really thinks there's something nefarious going on with that. but it's not abnormal for this to happen between an expert and a lawyer.
You gave at both the voir dire hearing a year ago and at the trial. Is that fair to say?
I don't think it's fair to say.
Okay.
I think that,
Tell me.
I don't think it's fair.
Okay.
I was convinced, if we would get into specifics, I was convinced of of my opinion back in the voir dire and in the trial. But I think I stated it wrong. I stated it as if I was talking to other doctors. They say in medicine that nothing is 100% in medicine. That's what we learn, when we go up through medical school and residency and whatever. And in my teachings, I always told people nothing is 100%. And that was the number that I was, that I thought I was being asked for. Basically, it was 100%. So that's why I stated my opinion the way I did. But anyways, as I went through material again, I was convinced back then, and I am still convinced right now that these are caused by dog bites. And not only that, but
So basically what she's saying is, I have the same opinion. I'm just more confident in it now, and I say it in a different way. Guess what? That's okay. You're allowed to do that. She would even be allowed to change her opinion a little bit if she wanted to. And guess what? That would be okay. It's not great. And if Brennan wants to cross-examine her and be like, your opinion completely changed between these two trials, I'm going to impeach you with your prior inconsistent statement. Guess what? You're allowed to do that. That would be good cross-examination. Maybe the jury wouldn't believe her, but you know what it doesn't do? It doesn't strike her as an expert. And that's the problem. As good as these discrepancies he's getting into, as some really good points I think he's making on cross about if an expert changes their opinion and is going back and forth with the lawyer, and before you said it this way and now you say it that way, you can cross-examine on that. That's great. Not a lot of experts give you that. But that is not what we're here to decide. Just like we're not here in this hearing to decide, is she right? Is it more likely a dog bite or a car accident? That's not what we're trying to decide. We're trying to decide, is she qualified based on her experience, expertise, and the methodology she used here? Is she qualified to be an expert and testify about these relevant facts and opinions in this case? And the only decent points made by the Commonwealth don't go against the questions that we're here to answer, or that the judge is here to answer. Matthew said, are they trying to keep out the accident recon experts? I haven't seen anything like that. Again, good luck. Like, that's what they do. Except a big step up they have on Dr. Russel is they've been qualified as experts in lots of different jurisdictions for lots of different cases. So that would be an uphill battle as well.
Dog attack.
If you were testifying honestly and earnestly before and using doctor speak, why would you need to change it for today, this report? Why not just continue to offer a natural, honest, thorough opinion that you had before? Why do you have to change it?
I came up with this. I became clearer and clearer every single time that I looked at the pictures, and I just realized that I understated the last time, that I misunderstood the question that was asked of me, regarding my opinion, and so I felt that I had to be clearer.
Did anybody point out to you that it'd be more helpful to the defense case if you had a more assertive opinion?
No, absolutely not.
So when you went through these days and months since the trial, did you get any new information that you looked at that made you realize you underscored the confidence in your opinion?
No.
Okay. Because in your earlier testimony, it's quite different.
I know.
So that was interesting. In your previous testimony, it's quite different. And she says, I know. If that's me, if I'm the prosecutor, I'm clipping that, right? I'm taking that citation from this hearing, which is under oath. It's a prior statement she's making. She has to then say the same thing at trial, or else you can impeach her. So if she tries to quibble with me at trial that her testimony is not different, I'm going to impeach her with that, where she says, I know, when he says your testimony is quite different. Once again, this doesn't really matter for Dobert. This isn't going to get her struck, but this is all stuff that's going to be good for him to use for cross-examination at the trial.
I want to do this gently, but I want to go through some of that.
Okay.
Okay. When you first testified, you had, how should I say this? You offered opinions that were less than certain about the genesis and cause of the wounds, didn't you?
I think it sounded like I was not certain. However, I was certain. I just didn't express it correctly.
Okay.
And that is one of the big things, is she's just more confident in it now. Yulia, that could very well be the case. Vaith said, Peter, show the book part. She owned Brennan by saying none of these authors have degrees. Everyone in court laughed. So I didn't clip that part mainly because the defense lawyers asked for that to be struck because there wasn't a question pending. So it didn't really even come before the court, number one. Number two, that wasn't actually proven to be a fact. She said, I don't even know if any of these people have degrees or something to that effect. Nobody agreed with that. So I'm not sure that that's true. I don't know if that's true or not. The point is, though, that was never put before the court. That was not a fact ever proven before the court, whether or not that book was even authoritative. And if it's not authoritative, it really doesn't matter. And the Commonwealth is going to have to prove that's authoritative if he's going to use it to strike her opinion, which they didn't do.
You first testified in the voir dire about some of these wounds. You were asked what kind of animal you thought caused the wounds, and you said, most likely a dog.
Correct.
Right. You didn't say beyond a reasonable degree of dog bite certainty, did you?
Objection, Your Honor.
What's the basis of the
The
question?
objection is, he said beyond a reasonable doubt, and that
No, he didn't say doubt. He said degree of medical certainty.
He said beyond.
Yeah, he said beyond a reasonable degree of medical certainty. He was just a slip of the tongue, and Brennan agrees he was wrong because he's like, let me just clear this up and ask it the right way.
Right, beyond a reasonable degree of medical certainty. So I heard you didn't get to the
That's not right. That's not the proper standard. So I'm glad Brennan fixed it, because it sounds like Judge Cannoni was just going to let it ride. And it's like, that's not appropriate. The defense attorney paying attention objects totally appropriately.
certainty. You just heard beyond reasonable and objected. So based on that, the objection's overruled.
Let me phrase to make it clear.
And I'll tell you what, people can say what they want about Brennan. Prior prosecutors, I think, would have just kept going. If the judge gives you the win, you take it. I don't think Brennan's going to be like that. The judge gave him the win there. He still corrected it to do it appropriately and properly. And I'm going to give him the benefit of the doubt as much as we're watching, because he could have just gone with that beyond a reasonable degree of medical certainty, which is just not how the standard's supposed to be done. We can argue about whether or not those words matter, but in my opinion, words do matter. And the words are picked very specifically. But he goes back and he corrects it anyways, which I appreciate.
You didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog.
I did in one of the okay, maybe in the next one. Okay, but yeah, if I wasn't asked about reasonable degree of medical certainty, I may not have expressed it.
The court herself asked you, do you know what kind of animal? And you said, yes, most likely a dog.
Yes.
Is that fair to say?
Yes,
So you didn't express certainty at that point?
yes, but again, thinking as a doctor and not a lawyer or a judge or someone. I'm thinking as a doctor. I'm thinking that it's never 100%, and so that's what I was going by. If I was going to be teaching medical students what those wounds were, or another group of wounds, I tell people never 100% in medicine. So that's where that came from, and I apologize if I confused the court.
I don't think there's any confusion. You use the word likely. The word,
Again, a snide remark. And Alan Jackson does the same thing. So, and Bev was Judge Cannoni was all over him during the first trial. So now we're going to get it from both sides, because he's had multiple under the breath type of comments that the defense team did a lot in the first trial. So a lot of that's going to be coming out in front of the jury unless Judge Cannoni really tightens it up. Sonia said, Peter, can this testimony be used in the upcoming trial if she's allowed to testify? It can be used to impeach her. Yes. If she says anything that's inconsistent with this testimony, yes, it can be used to impeach her. He said a reasonable degree of dog bite certainty. So it's scientific or medical certainty. That's what it should be. Thank you, Bob Jr., for gifting 10 more Lawyer memberships.
possibly is even less certain than likely, isn't it?
I don't know.
Well, when you're a doctor and you look at something, you say, well, the likelihood is this is the cause of this.
Oh, yeah,
That
okay,
would be a stronger opinion than saying it's possibly this.
correct.
Possible is even less certain, isn't it? At trial, when you were asked about the cause of the injuries, I'm going to quote you, and I can show you if you'd like. It's the trial transcript, page 19, line 21. What you said is, I believe that these injuries were sustained by an animal, possibly a large dog, because of the patent injuries.
Yes,
Is that your testimony?
yes.
Very different. I'll just finish if I could. Very different than what you're opining today at this hearing.
I'm sorry that you think it is, and I can understand how you believe it is, but it's not different to me. I believed it was a dog. I was convinced it was a dog then, but going by the no 100% in medicine, I didn't say that. I am still convinced it's dog. The one thing that's a little different is that it's an attack. I after counting the
He's like annoyed. This is his annoyed face. Like she's just talking and not answering a question I'm asking.
the series of wounds and whatever, I am convinced not only was a dog, striking once or twice, but it was actually multiple strikes by that dog.
Okay, now I want to get back to the testimony we were talking about, your testimony at trial under oath, okay? Your testimony is you believe they were sustained by an animal, possibly a large dog. You expressed uncertainty that you didn't even know or have an opinion about what type of animal caused these wounds at that time. Is that fair to say?
I was leaving room for if there was for instance, another kind of animal in the vicinity that, but there's no evidence to that. There's no, paw marks or anything in the ground.
What other animal do you think was in the vicinity that would have caused these?
I don't know, but I was just leaving that again. Being a
And by the way, these are all questions that are fine for Cross during trial. He is totally abandoned attacking her education and expertise. He has totally abandoned attacking the method in which she came up with her opinions, which is a losing battle. Maybe like Yulia said, he's practicing his cross, but he's not making any headway as to disqualify her as an expert here. If I'm the judge listening to this.
trained physician, there's no absolutes, and so that's what,
No.
the way I approached it.
Did
I'm
you-
sorry if
Did you inquire to see more discovery, to see if there was a pack of wild animals in 34 Fairview that would have caused this? Did you reach out to any of the witnesses or the lawyers and ask if there was any reports or information suggesting another animal?
I did not.
Were you curious?
I did not. I just didn't do it.
Okay. You were asked by Mr. Jackson, trial page 23, line 3. He provided the question, does this appear as it's a pattern injury that you see appear consistent with an animal or a large dog? And you said yes. So you included that this, again, could have been a dog or an animal in your opinion.
Mhm.
Yes?
I haven't.
So I'm sorry, we can't take we need a yes or no.
Oh, sorry.
Doctor.
Yes.
And he keeps asking the large animal or dog again. If he was a defense attorney and he's trying to poke holes, fine, this might be working, but he's not disqualifying her.
Again, at trial, page 23, line 6.
Trauger asked, Peter, on a scale of 1 to 100, how normal is this? What is this? A Dobert hearing challenging a expert witness's expertise? It probably happens in 50 to 75% of my cases, that there's some expert that one side wants to challenge something about what they're testifying to, either completely or partially. Why did Judge C scold Alessi for not stating the reason for the objection and then later ask for the reason? Is that really the law in Massachusetts? She scolded him for giving the reason and then later she asked for it. Frankly, I don't know if she's just, playing, he's the foreign guy, or not foreign, but out of town or whatever. And this is how it works here. But without a jury, I don't understand why it matters if we're not giving our reason for the objection. But maybe she's just trying to get him used to not giving the reason for his objection so he doesn't do it in front of the jury. But sometimes the judge needs to know the reason for the objection, especially for the record. We talked about this at the beginning of the trial. I don't get why argumentative or whatever, a one-word explanation of what the objection is, that protects the record. But again, it's how they do it, and that's how they did it in the trial as well.
You were asked, does the number of injuries that you see here relegated to just the right arm, is that consistent with an animal or a large dog? And you said, yes, it can be. Okay. Do you want to see your testimony? So I don't want to just put words in your mouth.
No, I trust you.
And so, thank you. So the question that you were asked was positing that it could have been not just a dog, but any animal. And you were agreeable to that at that time.
Again, thinking like a medical doctor, not a participant in a legal setting.
Not to belabor, but these are your words, so I want to talk to you about them. You were again asked, page 23, line 18, by Mr. Jackson, based on everything that we've discussed today, doctor, is it your opinion, based on a reasonable degree of medical certainty, that these injuries were from an animal attack, possibly a large dog? And you said yes. Correct?
Yes.
Okay. And so your opinions today that this was exclusively an animal attack caused by a large dog, that is much different in kind than the uncertainty and possibility that you admitted under oath during trial, in this case, the first time, actually the second time you testified about it. Wouldn't that be fair to say?
It sounds like it, yes.
Okay, I think this is a good point to stop because we need to get another date.
I think they ended up picking a date in early January, but that was the end of the hearing. And any headway I think Brennan made is not headway that's going to strike her as an expert. So, I mean, I haven't been really confident in a lot of how things are going to turn out in this case. I'm pretty confident Judge Cannoni's not going to strike her in her entirety. She may limit some of the things that Dr. Russell could testify to, but man, I would be truly shocked if she struck her altogether, but we'll kind of have to wait and see. Peter, not for the questioning, but for the attitude towards each other, 50-50, I'd say. Scale of 1 to 100, 50. It depends on the lawyer. Some lawyers, it happens in every case. Some lawyers, it never happens. Some experts are very condescending and they're jerks to the lawyers. So sometimes that creates the problem. So it does happen. It's not quite that unusual. Azam said, Peter, OT, have you ever been a witness in any case? I have not. I do have to agree with Brennan on one thing. I do believe that there was a pack of wild animals inside 34 Fairview. Touche. Could the defense call another dog bite expert as well? So usually most jurisdictions limit you to one expert per field. So if Dr. Russell is going to testify about dog bites, they usually wouldn't be allowed to call two. It'd be cumulative. But if she gets struck, I think they should be provided the opportunity to get another expert because they'd have a really good argument with the judge to extend deadlines. Because Judge, we had a dog bite expert in trial 1, unbeknownst to us and outside of our plans, you struck her. So give us the opportunity and time now to go find another one. And that would be appropriate in my opinion. All right. We went a little over today on Friday. Hope everybody has an awesome weekend. I'm excited about my weekend. I look forward to hanging out with you guys again next week. We have a very fun podcast posting Monday morning at 8 a.m. Make sure you subscribe and hit the reminder bell so you don't miss any of that stuff. Make sure you hit the like button on this video. Thanks for hanging today. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.